Welcome to Supreme Court this week, where I will take you through most important and must-know legal developments. Starting with the first, Supreme Court disposed of petitions challenging the guidelines issued by the University Grants Commission for conducting final exams by September 30 with following orders. The bench has refused the prayer to quash UGC guidelines to hold the exams. The directions of State Disaster Management Authority for cancelling exams in that particular state will prevail over the UGC direction. However, the direction of the State Disaster Management Authority to pass the students on the basis of previous performance is beyond the scope of Disaster Management Act. States and union territories cannot promote final year students without examinations, as ordered by the UGC. States and union territories given liberty to approach the UGC to seek postponement of the exams in the light of COVID-19 pandemic situation. In the next case, a 5-judge bench of Supreme Court on Thursday held that decision of a coordinate bench in E.V. Chinnaiya v. State of Andhra Pradesh requires to be revisited and referred the matter to the Chief Justice for placing it before an appropriate larger bench. The bench expressed the view that once a state government has the power to make reservations, it also has the power to make subclassifications, and that such subclassification will not amount to tinkering with the reservation list. In a federal structure, the state government cannot be denied the power to make laws to give preferential treatment to subcategories within the reservation list, Justice Arun Mishra observed while reading out the operative portion of the judgment. The next, in which Supreme Court refused to pass a pre-broadcast injunction order to stop the telecast of a show in Sudarshan TV, which was allegedly communalizing the selection of Muslims in UPSC examinations. In a petition filed by one Firoz Iqbal Khan, a bench of Justice D.Y. Chandrachud and K.M. Joseph stated that it has to desist from imposing a pre-broadcast injunction on the basis of an unverified transcript of a 49-second clip. The court noted that during the hearing it had been highlighted that the expression of views derogatory to a particular community had a diverse potential, and the petition had thus raised significant issues bearing on the protection of constitutional rights. In another, the Supreme Court, in judgment which was delivered on Friday, has held the police officers cannot register FIR, arrest, prosecute, or investigate in regard to cognizable offence under Chapter 4 of the Drugs and Cosmetic Act 1940. The bench held that an arrest can be made by the drug inspector in regard to cognizable offence falling under Chapter 4 of the Act, without any warrant and otherwise treating it as cognizable offence. In the next case, Supreme Court has held that no appeal can be maintained by victim under Section 372 of the Code of Criminal Procedure on the ground of inadequate sentence. The bench held that while upholding the Delhi High Court judgment which dismissed the appeal filed by a victim under Section 372 CRPC, seeking enhancement of sentence imposed by the convict by the trial court, the accused in this case was convicted for offence punishable under Sections 364A, 302 and 201 of Indian Penal Code. The father of the deceased boy filed appeal before the High Court challenging the order of sentence seeking the enhancement of sentence to death penalty. Now, in the next case, the Supreme Court has directed the state of Madhya Pradesh to suspend or cancel registration certificate of vehicles which do not possess a valid pollution under control certificate, and also initiate penal measures against the owner or the persons in possession or control of offending vehicle in accordance with law. The bench also observed that the National Green Tribunal has the power to direct a state government in order to strictly implement the requirement of vehicles to possess a display and a valid PUC certificate. In this case, the Supreme Court has observed that plea of title and adverse possession cannot be advanced simultaneously and from the same date. The bench observed that the claim of title from 1976 and the plea of adverse possession from 1976 cannot simultaneously hold. On failure to establish the plea of title, it was necessary to prove as to from which date did the possession of wife of the defendant amount to a hostile possession in a peaceful, open and continuous manner. The Supreme Court has observed that failure of developer to comply with contractual regulations to provide the flat to a flat purchaser within a contractually stipulated period amounts to a deficiency. In cases where there is a gross delay in handing over the possession of beyond contractual stipulated period, the jurisdiction of consumer forum to award just and reasonable compensation is not constrained by the terms of a rate in builder's agreement. The bench comprising Justice D.Y. Chandrachud and K.M. Joseph said. Now, this is the last one in which the Supreme Court upheld a Madhya Pradesh High Court order which relaxed the penalty imposed on several judicial employees in district court for having more than 2 children. As per Clause 4 of Rule 22 of Civil Services Conduct Rules 1965, a government servant having more than 2 children shall be deemed to be misconduct if one of them is born on or after 26 January 2001. The Madhya Pradesh High Court Establishment Recruitment and Conditions of Service Rules 2016 provided that the above rules which were applicable to Madhya Pradesh state government employees shall subject to such modification, variation and exceptions by the High Court. ये थी इस हफ्ते की अपडेट्स। अगर आपको पिछले हफ्ते या फिर पिछले हफ्ते की अपडेट्स के बारे में जानना है तो इसके भी वीडियोस अवेलेबल है मेरे चैनल पे, और साथ ही आने वाले वीक्स पर भी ऐसी ही वीडियो आती रहेगी। तो कहने का मतलब ये है कि मेरे चैनल को सब्सक्राइब करिए और देश के लीगल डेवलपमेंट्स पे अपनी नज़र बनाए रखें। थैंक यू।